All right, good morning. The appellate court for the state of Connecticut is now open and in session. For the record, we are conducting this hearing virtually via Teams and are live streaming this hearing on YouTube. Counsel and parties are advised that to the extent that there is statutorily protected parties and or information here, that you take extra care not to reveal said protected information. I would also ask that everyone participating in the hearing identify themselves at this time, starting with the judges, then the appellant, and then finally counsel for the appellee. I am Judge Elgo.
I am Judge Suarez.
I am Judge Devlin.
Sir?
Pierre, Gregory Pierre.
All right, good morning.
Attorney Melissa Patterson, Senior Assistant State's Attorney representing the state of Connecticut.
All right, thank you very much. For the record, I note that I can hear and see everyone. Please let us know if in the course of your argument you're experiencing any difficulties hearing or seeing the participants. If you should lose your audio or video capability, please log out and retry the Teams link, which was sent to you for this hearing. Then we'll take a pause in the recording in the proceedings. All participants must keep their video on and remain in view out of respect for the process and the participants. All participants are also asked to keep your microphones off and muted when you are not speaking. The judges will raise their hand if they have a question to avoid talking over whoever is speaking, but will interrupt if you, for some reason, do not see them. Please keep in mind that while this is a virtual hearing, all participants are expected to conduct themselves with the same formality and respect for the process as you would in our courtroom. Each side will be permitted 20 minutes of argument. The appellant may reserve a portion of that time for rebuttal and should advise me before you begin how much, if any, time is requested for rebuttal. Judge Suarez has kindly agreed to be our timekeeper today and will give you a 2-minute warning and when your time is up. So right now we will be hearing State versus Pierre. I will also note that there was a court order and notice for the parties, if they would, address the impact of State versus Smith. Mr. Pierre, you may proceed, and if you would let me know how much time, if any, you would like for rebuttal.
Okay. All right. I just want to ask before I start, is it going to be the same outcome in Smith, right? As far as New London doesn't have jurisdiction at the end, so do we still have to go through the proceeding if it's going to be the same outcome? So that's what I would like to ask. As far as getting it sent back down to New London for dismissal.
Well, we can't really decide that now, sir, but we do want to hear from you with respect to what your thoughts are, and we're going to be asking the state, but certainly we are going to be looking at State versus Smith to see just exactly how applicable that case is to your case as well. Though it does appear to have a lot of similarities.
Yes, because we worked on it together when we was doing this, so I know it's going to be similar in all aspects. That's why I was raising right now. Okay. Where do I start? Okay, thank you for allowing me to be heard. I take apologies for my lack of polished courtroom professionalism. All right. I believe that my position on my sentence, using the vacator approach instead of the merger approach that the trial court used in sentencing, is the proper approach. And this position has validation in current law, validation both at the state and federal level of law. I ask that this honorable court take judicial notice of State versus Polanco, 308 Connecticut, 242, 2013, and State versus Miranda, 317 Connecticut, 74, 2015, as well as Rutledge versus United States, 517 United States, 292, 1996. Your Honor, this is the classic case of cumulative convictions, sentence for felony and murder, manslaughter first, and kidnapping violating my constitutionally protected right against double jeopardy, because they arose from the killing of a single victim. This is also a classic example of the erroneous and now discredited use of the merger remedy beyond greater and lesser included offenses. In fact, I quote, court is not aware of any reason why the vacator remedy should not be applied with equal force to other scenarios in which cumulative convictions violate the double jeopardy clause. Miranda at 746. Additionally, the jurisprudential underpinning to this court's approval of the merger approach in Chicano have been repudiated, and that the merger approach is now at odds with the remedy utilized almost uniformly at the Circuit Courts of Appeals. Miranda at 749. Clearly, Your Honors, the trial court used the merger approach. In my case, is exactly the issue that our state Supreme Court warns against in light of new evolved law. Hence this appeal here. Now, if I may summarize facts and case history of our Supreme Court evolution of the vacator versus merger remedies. Polanco and Miranda do a good job on that. And yet, after Rutledge, our Supreme Court did readopt the vacator approach exclusively over the merger approach. It stated it not only brought us in line with federal law, it created harmony and consistency to our state judicial system. And I quote, it is fitting to continue harmonizing of our approach vacator with the federal system. And analogically,
Pierre,
yes.
I hate to interrupt you because I don't want to interrupt your flow, but first of all, I just wanted to clarify and ask again if you wanted any rebuttal time after your argument, whatever time you want out of your 20 minutes, because we can add it on. We can take that time off and add it to the other side after your opponent speaks.
Oh yeah, probably like a minute or two.
Okay, all right. Thank you very much. I think Judge Suarez can make that adjustment. All right, so go ahead.
All right. And then I believe by requiring usage of the vacator approach beyond cumulative, beyond greater and lesser included scenarios, Okay, my bad. Or included scenarios in other scenarios in which cumulative convictions violate the double jeopardy clause. We promote internal consistency and eliminate potential future confusion with our own state judicial system. Miranda at 497. Subsequently, Your Honor, it becomes imperative that we indeed revisit sentences that have erroneously used the merger method in the past to ensure that we have not exposed ourselves to violations of the double jeopardy clause. I respectfully disagree with the Superior Court's assertion that Polanco and Miranda do not apply retroactively. Isn't it similar to what's been going on in federal and state courts regarding sentences to minors to life without possibilities of parole? As the Honorable Court knows, our Supreme Court of the United States has now ruled that it was cruel and unusual punishments to sentence minors to life without parole. So of course, federal and state courts are now all harmonizing their judicial system of its minors. Now, of course, minors do have the access to at parole. There is a similar evolution, if you will, with my pre-Chicano merger sentence that screams to be revisited as well in light of the changed ruling of Polanco and Miranda and Rutledge. The state's concern that by using the vacator method here, there is a potential for me to evade prosecution if indeed I somehow miraculously overturn the manslaughter one and the kidnapping. It's baseless. All agree, Polanco, Miranda, and Rutledge, that nothing in their new ruling preclude the state from resurrecting the felony murder and the kidnapping charges. In fact, our sister state of Washington in State versus Schwab, 163, 664, 2013, resurrected charges and still comported with Rutledge. Our vacator remedy is no more final than the merger remedy, Miranda at 750. I or any other inmate would be escaping punishment. Our state Supreme Court has explicitly expressed concerns of our past use of the merger remedy in regard to double jeopardy issues. And I quote, the OPEC remedy of merger cannot be implemented to consistently protect defendants from the potential collateral consequences of having an unauthorized cumulative homicide conviction, Miranda at 753. Additionally, our courts say the merger approach distorts how courts memorialize the convictions on the record. They stated that our courts do not all use the same methodology, but that the convictions are on record. And so once again, our state Supreme Court was concerned that this too would be in direct conflict with federal law, particularly with Boer versus United States, 470 United States 865, 1985. And I quote, second conviction for the same offense, even if it results in no greater sentence, is an impermissible punishment. And indeed, in this holding in Boer contradicts the Superior Court's opinion in my case here. The Superior Court, the merger remedy the trial court used did not increase my sentence regarding the kidnapping charges, but did so on manslaughter 1 and felony murder. And by felony murder being the illegal sentence and the controlling sentence, it enhanced my sentence by 35 extra years. I'm relying on Boer versus United States 470 United States 856, 865, 1985, which states the second conviction for the same offense, even if it results in no greater punishment. But in this case, it did. And in this case, it did in an impermissible punishment. So it seems to say no harm, no foul. I respectfully disagree. Boer clearly states that fact still creates a foul. In sum, I respectfully disagree with Superior Court's assertion that Polanco and Miranda are not retroactively applied and that my sentence under the merger remedy is inconsistent of new established law. My situation is the other scenario that courts allude to in Miranda. It is indeed now ripe for discussion and revisioning. Thank you for this opportunity.
Thank you very
Yes.
Judge Devlin has a question for you, sir.
So, Mr. Pierre,
Yes.
when you were in front of Judge Strackbon in New London,
Yes.
there was like a back and forth between you and the judge.
Mhm.
And the judge asked you whether you thought if you prevailed, if you won your motion to correct the legal sentence, it would have any effect on your sentence, on your total effective sentence. And I recollected that the transcript said that you didn't think it would have any effect, but have you changed your view on that?
Yes, absolutely. I did.
But do you acknowledge that that's what you told the judge?
Yes.
Okay.
I did.
So explain to me how you think it would change your sentence, the 85-year total effective sentence.
Because I read Boer and I see Boer states as far as for the same thing, which I should have incorporated. That's where I messed up at, and I should have cleared that up when I was there, and I did not. And I see Boer states that for the same charge, because they could have gave me manslaughter and still ran in concurrent with the felony murder but the same total effective sentence. But that wasn't done, but it was enhanced. And even though I still would have challenged one of them, and they said it's for the same crime, for the same charge, the second one would be impermissible. And my view is that the felony murder is illegal because it's the same thing as the manslaughter. The same thing with the kidnappings. Both kidnappings, the second kidnapping would have been is illegal because they're the same exact thing.
Okay, thank you for that. Thank you.
All right. Thank you very much. Counsel?
May it please the court. As noted before, my name is Melissa Patterson, Senior Assistant State's Attorney representing the state of Connecticut in this matter. It's well established that pursuant to our rules of practice, the judicial authority may at any time correct an illegal sentence. It's equally well established that a motion to correct is a narrow exception to the common law rule that once a defendant's sentence has begun, the authority of the sentencing court to modify that sentence terminates. Recently, our Supreme Court in State versus Jeffrey Smith addressed the issue of whether a trial court has jurisdiction to review a defendant's motion to correct an illegal sentence that challenges a cumulative homicide conviction that had been previously improperly merged under Chicano for purposes of double jeopardy. The Smith court held that where there is no sentence imposed on the merged cumulative conviction and the remedy of vacatur would not have any effect on the length, computation, or structure of the sentence, the trial court lacks jurisdiction because the defendant's motion seeks only to modify his conviction rather than his sentence. This court is bound by our Supreme Court's decision in Smith. So in the present case, as in Smith, the trial court merged the manslaughter conviction with the felony murder conviction and imposed sentence only on the felony murder conviction. That's the 60 years. So because the defendant's motion to correct sought only modification of the merged conviction for which there was no sentence, and vacatur would not affect the length, computation, or structure of the sentence, the trial court in this case, as in Smith, did not have jurisdiction over that portion of the defendant's motion to correct an illegal sentence. Accordingly, consistent with Smith, the proper resolution would be to have this court remand the case to the trial court for dismissal rather than denial of that portion of the defendant's motion. Now, with regard to the defendant's second claim under Ball, which is that as my colleague, the former attorney on this case, had briefed in his appellate brief, his understanding was because of the wording in Ball that discusses the second conviction, that because the felony conviction, or excuse me, the felony murder charge was the second in the information and the second for which the jury issued its decision, that because chronologically it came second, that means that should have been the sentence or the conviction to be vacated. As we have argued in our brief, we disagree with that. That's not the meaning of Ball. Certainly with regard to State versus John, which I know the defendant has cited to in his brief, in that case, it was the manslaughter conviction that was, in that case, vacated because that was under the vacatur rule. But also in Miranda, State versus Miranda, which the defendant cited to, although it's slightly different where it's capital felony and felony murder, the trial court had vacated and then, or excuse me, the Supreme Court issued vacatur of the felony murder and the murder, which are less severe, or they are lower classes in some degree to the capital felony. So although our law does not discuss specifically which order it should come in, it seems that our law, at least John without elaboration, had vacated the manslaughter as opposed to the felony murder. So to the extent that that was part of the defendant's claim, we would submit that the order in which the trial court merged the manslaughter and kept the felony murder was an appropriate decision. And then also the defendant has raised a double jeopardy claim with regard to the two kidnapping charges. Again, as my colleague had briefed, my colleague cited to State versus Gonzalez, but I would also note for the court that this court's decision in State versus Smith also addressed this question of the two kidnapping convictions under the two subsections of 53A 92 sub A sub 2, because each requires proof that the other does not. There was no double jeopardy concern. And for those reasons, I would just parse out that it is the defendant's first claim with regard to the felony murder manslaughter. That would be properly a dismissal of that portion of the motion to correct. But with regard to the kidnapping claim, the trial court's denial of that issue was proper for purposes of the motion to correct. I am happy to answer any of the court's questions. Seeing none, oh, yes, Your Honor.
So your position is that this court has jurisdiction, does not have jurisdiction to consider whether this whole retroactivity claim with respect to the felony murder and the manslaughter conviction, that based on the Supreme Court's ruling, we don't have jurisdiction to consider that, but we would have jurisdiction to consider the merits of the claim regarding the two kidnapping counts?
Because, yes, Your Honor, because that is a true double jeopardy claim, although meritless based on our jurisprudence from Tweedy Gonzalez, and then on up through to State versus Smith. So
But how would that affect the sentence? Because you receive concurrent sentences, right?
it would not, but it would certainly change the structure, because with regard to the kidnapping, there were 2 kidnappings, each had 25 years imposed for each one. They were concurrent to each other, but consecutive to the felony murder. So under the language of State versus Smith, that talks about the structure computation of, it would seem to fall under that.
Okay, thank you.
Seeing no additional questions from the court, I would ask this court to dismiss and deny, remand for dismissal and denial of the defendant's motion. Thank you.
I missed that because it just froze on me. What you said? Dismiss, for the court to dismiss or remand and do what?
I'm happy to repeat that, Your Honor.
Yes, please.
Mr. Pierre, all I was saying, it was just a follow-up of just with regard to your motion. I'm arguing that this court remand for dismissal of the manslaughter felony murder challenge, and that the denial can stand with regard to the kidnapping claim that you made.
Okay.
Thank you, Your Honors.
Thank you. Mr. Pierre, you do have some additional time left if you would like to use it. You don't have to, but certainly you're welcome to offer some rebuttal.
Oh yeah, so I just want to ask a question. Oh yeah, I just want to ask a quick question. So she said that
I just want to make clear that we can't really advise you, sir. So if there's anything procedural that we can help you with, but we can't really advise you as to the law. So this is your opportunity to tell us how you think we should decide your case, given what the law is as you understand it. Okay?
Okay. I'm straight. I'm all set.
You're all set? Okay. All right. Thank you very much, sir. Thank you, counsel. We appreciate your arguments today, and we are sorry for the technological concerns that you had to endure. We'll take this matter under advisement, and we will recess until 10:30. Thank you again.
All right, so I'm done.